Good day, everyone, and welcome. My name is Dan Sampaio, and I'm delighted to open today's Mondac webinar in association with People and Culture Strategies, discussing employer responsibilities and employee rights in Australia. We are joined by the wonderful Joydeep Hor to lead today's discussion. Joydeep is the founder and managing principal of People and Culture Strategies. Joydeep is a graduate of Harvard Business School's Owner-President Management Program and one of Australia's most high-profile lawyers and legal entrepreneurs. He is a fellow of the Australian Human Resources Institute and a chartered fellow of the UK's CIPD. The highly regarded Who's Who Legal Labour Employment and Benefits 2020 edition recognised Joydeep as a global elite thought leader in this area of the law, one of only 2 lawyers in Australia and 6 in the entire Asia Pacific region. Before I hand you over to Joydeep, a housekeeping item, you are able to submit questions to Joydeep by typing them into the questions pane of the toolbar on the right-hand side of your page. We will endeavour to answer as many questions as possible during our Q&A at the end of today's session, but please do reach out to Joydeep after the webinar for any additional information. It's now my pleasure to hand you over to Joydeep to begin. Thank you.
Thanks very much, Dan, and let me begin by thanking and acknowledging the wonderful support provided by Dan and the team at Mondac. It's a great privilege for People and Culture Strategies to be presenting this particular webinar, and a great privilege for me to be doing so. Personally, let me extend a warm welcome to those of you who have decided to join us for what will be a pretty dense webinar in terms of the content that I will cover. And I'm going to try to do so in as meaningful and impactful way as I possibly can, recognizing that there's a fair amount of content, and I'm going to try to keep it as relevant for you as probably individuals who have either got a presence in Australia. Some of you I know are joining from Australia, but I appreciate that we do have a global audience on this webinar, and I understand that some of you may have a presence in Australia, which might be small, which might be significant. You may have some kind of legal or operational HR type responsibility in relation to Australia. And the purpose of this webinar is to really tell you what are the critical things that you need to be aware of from an employee rights and an employer responsibilities perspective. The way in which I'm going to work through that particular content is, rather than focus on employee rights separately and employer responsibilities separately, look at how these things actually play out in real time and at a practical level, which is more relevantly about how these things coexist, how they might conflict, and what does that mean for those of you who need to be aware of this potential tension between employee rights and employer responsibilities. Before I get into the detail, a very quick word about People and Culture Strategies, or PCS as we like to refer to ourselves. So we're a boutique or specialist labour and employment law firm based in Sydney, but servicing clients all around Australia and internationally in respect of multinationals' Australian operations. We provide work across all aspects of labour and employment law, including discrimination, harassment, bullying. And one of the unique things about our business is that we also do a lot of work in areas such as auditing of culture and a strong focus on education and leadership development, which are critical aspects, as I'll come to in the course of this webinar, for employers who are wanting to stay ahead of the game and really manage their legal risk. So we are a slightly unusual law firm in that we've got a strong focus on the prevention rather than the typical domain of lawyers, not just here in Australia, but around the world, which is a strong focus on the pure reaction. Let me start by also making some overview comments about the Australian employment law landscape. And one of the things that's important to note is the Australian employment landscape is really quite unique. I like to think that it sits somewhere between the freedoms and the employer-friendly world that exists in the US, and probably at another extreme, some of the more strict restrictions and prohibitions that exist in respect of employment rights in a country such as France or other parts of continental Europe. Australia has quite a unique set of dynamics when it comes to the role of unions, for example, which is not quite as significant as what it would be in organizations or countries such as Germany, where you've got works councils that are prevalent. But they don't have anywhere near the same kind of significant impact here in Australia, but in certain industries, they do have quite a significant impact. So Australia is very much a hybrid when it comes to employment law, but there are some quite unique features which I will be drawing your attention to in the course of this webinar. And what I'd suggest is that rather than being too focused on the granular detail of the points that I'm going to be covering, accept that as a critical need to know, accept the content that I'll be working through as a critical need to know in the main areas of the regulation of employment, with a focus on what it means for businesses and organisations that are doing business in Australia and employing people here. So I'm going to start by sharing a little bit about the primary piece of legislation here in Australia. And in doing so, it would be silly of me, or foolish of me, and certainly naive of me to not walk through very briefly the fact that over the history of Australia, we're a young country by global standards. The Commonwealth of Australia was formed in 1901, so that's some 121 years ago. Prior to that, Australia, as we now know it and as you know it, was an amalgam of several different colonies, which are now relevantly states and territories. And what's important about this history is that when it comes to the regulation of employment, labour and employment law in an Australian context, prior to 1901, that was all done on a state-by-state basis. And what's very important to appreciate is that what now exists as harmonised labour and employment law in Australia was something that only came into effect in that unified way in 2006. So for the first 105 years of Australia's history post-Commonwealth, the system was extremely convoluted and complicated because you had state systems of regulation with some aspects of Commonwealth or federal legislation and regulation. All of that was made a lot more streamlined and a lot more convenient for employers in Australia in 2006 as a result of what was then referred to as the Workplace Relations Act and some significant reforms that were introduced in the form of what is colloquially still referred to as the Work Choices Laws. But as of 2009, the main piece of legislation here in Australia is referred to as the Fair Work Act. And that has remained the primary piece of legislation dealing with employment and all of the things that is encapsulated in an Australian context since 2009. And some of you may be aware that we've fairly recently had a change in government at Commonwealth level. The Conservative, Liberal and National Coalition was voted out and replaced with the more union-friendly Australian Labor Party. And while there are some changes that have been mooted, none of those changes are likely to be significant. So what that means is that if you are an employer wanting to know what's the main piece of legislation that I have to worry about in an Australian context, you need to be aware that it is the Fair Work Act. So what does the Fair Work Act do? Well, the Fair Work Act covers a whole range of obligations, rights, responsibilities in an employment context. And I'm going to walk you through the critical parts of that right now. One of the main things introduced by the Fair Work Act, and at this time in 2006, when all of the states effectively had their state employment laws subsumed into the federal Commonwealth legal system, was the introduction of a set of minimum standards. And under the Fair Work Act, they are referred to as the National Employment Standards, the NES. If you are an employer of Australian employees, if you're an overseas corporation or an Australian company or constitutional corporation which is going to cover a significant number of employers, the vast majority of employers, in fact, and probably, I'd assume, most of the employers that are represented on today's webinar. You have a legal obligation to ensure that you are adhering to the national employment standards in respect of every single employee who you employ here in Australia. The National Employment Standards deals with 10 core entitlements for employees. I'm not going to go through all of them, but some of them relate to things such as annual leave or holidays, personal leave, or when someone is sick or has carers' responsibilities. It also deals with matters such as a minimum period of notice that has to be given to terminate someone's employment. It deals with what has to be paid to employees if you as the employer decide to make their roles redundant. It deals with rights that certain employees have to request flexible working arrangements. It deals with parental leave. It also deals with some administrative aspects of employment in Australia, such as the fact that when a new employee starts working for you, you have to issue them with a document. It's called a Fair Work Information Statement. Regardless of what work is being done by a particular employee in an Australian context, the critical message here is that if you've got them employed under a contract of employment or letter of appointment or employment agreement, call it what you will. I prefer the terminology of a contract as a generic term to talk about all of those different phrases that might be used. If you've got them employed under a contract, that contract must, at the minimum, reflect the obligations you have to that person under the National Employment Standards. If you do not, then you are in breach of the Fair Work Act, and in an Australian context, being in breach of the Fair Work Act is something for which your organisation can be prosecuted by an organisation known as the Fair Work Ombudsman, and if found guilty, then there can be significant financial penalties imposed on your organisation, and those penalties and prosecutions may be meted out towards certain individuals in your organisation as well. So you need to make sure that you are complying with your obligations under the National Employment Standards. Another feature of the Fair Work Act is to deal with quite a unique instrument or set of instruments that exist in an Australian context, which are referred to as awards. Now, an award is a document that sets out minimum terms and conditions of employment of employees based on the particular industry in which they might work. So, for example, if you are an employer in the manufacturing industry, if you are a manufacturer of food products or beverages or household items, then there is an award called the Manufacturing and Associated Industries Award that sets out the minimum terms and conditions that you have to adhere to if you are employing people in that particular industry. Now, you might be thinking, well, hang on a second, I thought the National Employment Standards was the thing that I had to comply with. And that's absolutely right. The National Employment Standards has to be complied with by an employer for all employees, regardless of what industry that they are operating in and regardless of what location. The particular awards that apply on an industry by industry basis work hand in hand with those National Employment Standards, the effect of which is to create specific conditions for particular people in particular industries. So if you are a manufacturing employer, not only do you have to comply with the National Employment Standards, but you also have to comply with that Manufacturing and Associated Industries Award for those employees who have their employment covered by that award. What do I mean by that? Well, the way awards are written, Whereas the national employment standards apply universally, regardless of role, regardless of income level, regardless of seniority or longevity. The national employment standards apply, as I say, universally, but awards, on the other hand, apply, yes, in respect of particular industries, but they also only apply to particular classifications, particular jobs, particular types of work done in those industries. And most commonly and typically, people who are employed or engaged in supervisory or management roles are likely to be excluded from the coverage of those particular awards. So for those employees, let's say you've got a manager as a manufacturing business here in Australia, that manager's minimum terms and conditions are going to be set out in the national employment standards, but unlikely to be dealt with in the manufacturing award, even though you are an employer and that manager is an employee in the manufacturing industry. However, if you're dealing with a factory worker or someone who is actually operating the machinery in your manufacturing plant or site, they're going to have the national employment standards and they're going to have the terms of the manufacturing award apply to them. On a day-to-day basis, we are regularly advising employers on the critical need for them to be complying with their obligations under the award. And what I can share with you anecdotally is that while most employers are pretty good at complying with the national employment standards, a lot of employers and a lot of very significant employers are not complying with the terms of the award. And what they're not doing is doing the necessary audits and checks to make sure that they know which award and which classification under an award may apply to different people in their organization. I have a lot of my clients who will say to me, oh, that award doesn't apply to us because we pay people so much above what the award rates are. And it comes as a great surprise to them that the way the law works is the mere fact that you're paying someone above the rates that that award might set or prescribe does not mean that the rest of the award does not apply to your organization. There are provisions that might deal with break times or that might deal with particular allowances or what are referred to as penalty rates if people are working on weekends or working overtime or any number of other things that still apply in respect of those employees' employment and that are binding on you as an employer. And this is one of the most critical watch out areas for employers in Australia, understanding their award obligations and ensuring that they are doing the necessary and regular audits and checks to make sure that they are complying with their obligations under the award. Once again, in the same way that if you don't comply with your obligations under the national employment standards, you can be the subject of prosecution, you can also be the subject of prosecution and penalty for failing to comply with your obligations under an award. And there have been numerous high-profile employers in Australia, particularly in the last 10 years, who have been in the sights and targeted by the Fair Work Ombudsman and who have either been fined significantly or have had to enter into other commitments or undertakings to provide compensation and the equivalent of penalties as a result of not complying with their award obligations. So far we've talked about the Fair Work Act, the National Employment Standards as a part of the Fair Work Act, the award system as a part of the Fair Work Act. The next part of the Fair Work Act that I want to talk to you about is the idea or notion of enterprise agreements. And effectively, what we're touching on at this particular point in time is the whole idea around minimum terms and conditions or employee rights and employer responsibilities when it comes to the terms and conditions that must be afforded to employees. The National Employment Standards is the base of the pyramid, if you like. Awards will apply based on industry and based on job type. And the third layer that might apply is if your organization has entered into what's referred to as an enterprise agreement. Enterprise agreements in Australia have been in place for the last 35, 40 years, and they were introduced into the Australian landscape by governments to allow employers to negotiate and bargain with their workforces and those industrial organisations such as unions who had the right to represent employees in a particular workforce as to particular terms and conditions that would be considered most appropriate for a specific workplace. So under the current law, national employment standards apply across the board. Manufacturing and associated industries award is an example of one award. There's a finance industry award. There's all sorts of different awards based on different industries. So they will apply if you're in that industry. But the enterprise agreement allows you as the specific employer in any industry, or sometimes even in no industry in particular, to bargain with your workforce and agree with them on the most appropriate terms and conditions. And so long as you are meeting a test or a standard or a threshold that is referred to as the BOOT, BOOT, standing for the Better Off Overall test. In other words, the terms and conditions that you agree to through your bargain must put the relevant employees in a better position overall than they would have been if there was no agreement entered into and if their employment was regulated by the Fair Work Act's national employment standards and the modern award that might apply. So if you want to enter into an enterprise agreement, you have to go through a process that is referred to as bargaining. And as its name suggests, bargaining involves negotiation. Bargaining involves trade-offs. Employers cannot be forced to enter into an enterprise agreement. However, they do have obligations to ensure that if they are bargaining, that they are bargaining in good faith. And there are consequences for employers who do not bargain in good faith, and they will usually be taken to task by those unions that will be bargaining on the other side of the table against that particular employer. There's a lot of regulation and prescription and rules that have to be followed in the context of bargaining and in the context of agreement making. What typically happens by way of commentary is that some organisations enter into an enterprise agreement at a particular point in time in their history, and they typically keep rolling over with an enterprise agreement. They don't have to. You can move away from an enterprise agreement. Enterprise agreements typically are either 2, 3, or 4 years in duration. And there's no requirement that you have to keep negotiating or keep bargaining, but the practice typically is that once you do have an enterprise agreement, then you tend to stick to it. And there's lots of reasons for that, one of which is that employees are often perceived to have an expectation that they will have an enterprise agreement. Often the union sees themselves as having greater relevance in an organisation if they can bargain every 2 or 3 or 4 years with the employer. So it's always a courageous and brave thing for an employer to say, you know what, we're going to move away from having an enterprise agreement. So quick recap so far. Fair Work Act sets out the national employment standards, sets out the modern awards that apply, and also deals with enterprise bargaining. They are the 3 tiers that are the minimum terms and conditions of employment that will apply in respect of your employees here in Australia. The only other thing to add on to that is what might be set out in the context of a contract of employment. And I'm going to come back to that a little bit later on. So let's park for the time being the issue of terms and conditions. And let's move to one of the more unique aspects of Australian employment law and the Australian employment law landscape, which is the challenges that are associated with the termination of employment of particular employees. Now in Australia, there are remedies available to employees whose employment is terminated so long as they satisfy certain criteria. The first criteria is that the employee must be below the annual remuneration threshold. Now, that's a figure that is indexed or increased on the 1st of July every year in accordance with inflation and certain other factors. Currently, in respect of the year that it will run from 1 July 2022 to 30 June 2023, that remuneration figure is $160,000. Now, there are some technicalities around whether that's base salary or inclusive of superannuation, other things. We don't have time to get into that now. Just be aware that there is a remuneration threshold, that figure increases on the 1st of July each year, and at the moment that's a figure of $160,000. So you have to be earning less than that in order to bring an unfair dismissal claim. Similarly, you can't be a casual employee who has less than 12 months service with the employer. You also have to be an employee who has passed their minimum employment period, which for employers that employ more than 15 employees, and that's not just 15 employees here in Australia, that's 15 employees amongst the group of companies for that employer. That minimum employment period is a period of 6 months. So if you have terminated someone's employment in the first 6 months, they will not be able to bring an unfair dismissal claim against you. So they are the main things to be aware of in terms of who can bring an unfair dismissal claim. Well, what does it mean if someone brings an unfair dismissal claim? If someone's employment is terminated, they have 14 days within which to bring a claim for unfair dismissal. That matter is dealt with by the Fair Work Commission, initially through a process of what is referred to as conciliation. And if conciliation is unsuccessful, then it will be listed for an arbitration or a hearing. And it's important to note that if the Fair Work Commission finds that someone has been unfairly dismissed, the Fair Work Commission has the power to reinstate that employee to the role from which they were dismissed. If that role doesn't exist or has been filled by someone else, the Fair Work Commission has the power to order the employer to re-employ that person. So they can say to you, that role may be filled, but you have to find that particular person a role, because that's your punishment for having unfairly dismissed them. The third alternative is that the Fair Work Commission can order compensation, and compensation is capped at 6 months of remuneration. But often compensation is awarded in addition to the back pay from the period that someone's employment was terminated to the date on which the decision is handed down. How does an employer avoid an unfair dismissal claim? Well, I've written a book on managing termination of employment, and I share that because, as it would suggest to you by the fact that a book has been written about it, and it's by no means the only book that's been written about termination of employment in Australia, termination of employment in an Australian context is very complex, and it is something which we would say no employer should do without seeking diligent and thorough and particular specialized legal advice, because you do not want to have an employee who you have dismissed reinstated into your organization. There is nothing that is more humiliating or embarrassing for an employer and the credibility of the managers of that employer than to have an employee reinstated. And if there's one thing which employers should be getting advice on in an employment context, it is before they terminate the employment of any employee. In short, however, what I would say to employers, as I say to all my clients, is that you need to ensure that you have a valid reason for termination. And that valid reason should fall into one of 4 categories. The first category is that it can be a redundancy. In other words, you no longer need the position to be performed by anyone. The second reason is poor performance, persistent poor performance. The third reason is that the employee has engaged in misconduct, theft, assault, serious breach of policies and procedures. And the final category or reason or valid reason for termination is medical incapacity. Now, unless your reason for terminating someone's employment in Australia falls within one of those 4 categories, you will likely be exposed to that person bringing an unfair dismissal claim against you and a risk of reinstatement. So the first thing to note is you have to have a valid reason. The next thing to note is even when you do have a valid reason, you are required to and expected to follow procedural fairness. And procedural fairness is all about process, and the right process depends on which reason is the reason that you are relying on to terminate the employment. So for example, procedural fairness in a redundancy situation looks quite different to procedural fairness in the context of a poor performance or injured in a medical incapacity termination. So very complex and something about which you should be seeking advice. Now, it doesn't end there when it comes to the consequences or risks arising from termination of employment here in Australia. Even though employees who are earning above $160,000 annually are unable to bring an unfair dismissal claim, under the Fair Work Act, and I should mention that unfair dismissal is also addressed under the Fair Work Act. But under the Fair Work Act, there is a separate regime, which is referred to as the General Protections Regime, whereby if an employee has their employment terminated for any number of reasons, which might include reasons to do with their attributes or features, such as their sex or race or age or the fact they have a disability, but it's not just limited to those commonly known discrimination areas. It also includes where someone has had their employment terminated, for example, because they've asked questions about their employment terms and conditions, or they've made a complaint against their manager, or made a complaint against the employer, or they've been a whistleblower. Now, in these particular situations, an employee is protected. And if their employment is terminated and they allege and can prove that their employment was terminated because of one of those protected reasons, then that employee can apply to the Fair Work Commission. And while that is not a case that will be heard in the Fair Work Commission, it will actually be heard in the court system, that employee too can be reinstated. And more importantly, and a greater risk for employers, is that there is compensation that can be awarded to that employee, which has no cap. Whereas unfair dismissal, there's a cap of 6 months. General protections claims there's no cap. What this means is that, as I said before, termination of employment of any employee in an Australian context is a high risk matter. Australia, while some would say is not as highly litigious a society as may exist in other parts of the world, it is pretty closely following behind those other countries. Most employees whose employment is terminated, particularly in metropolitan areas, know that they can challenge it. And most of them know where to go in order to get advice. And there are plenty of legal firms and lawyers who will provide them support, often on a no-win, no-fee basis. And that's an important part of the landscape. Unions will often provide that advice and support. It's not a difficult or expensive exercise for a dismissed employee to challenge the termination of their employment, which is why a big part of what we do, the work we do with our clients, is to help them to achieve the outcomes that they want if it involves termination of employment, but to do so in a manner that is likely to minimize the risk of any claims being brought, or if claims are brought, ensuring that the employer is in the strongest possible position to defend those particular claims. I'm going to move away from the Fair Work Act for a moment and talk a little bit about some of the matters that I was touching on when talking about the general protections regime. Australia, like many other countries, has laws, strict laws, that prohibit discrimination and other behaviours in a workplace context. It is unlawful under Australian laws at Commonwealth level and in various states and territories to discriminate against someone on the grounds of their sex, the fact that they are pregnant, race, age, disability, and numerous other grounds. That discrimination does not just have to be termination of employment. That discrimination can be conduct that occurs during employment. It might be demoting someone, not giving someone a promotion, withholding a bonus from someone. Any form of differential or disparate treatment of people which is linked to or primarily attributable to a ground that is protected by law is going to fall foul of Australian discrimination laws. I want to talk in this context a little bit more specifically about the two most relevant challenges that are mounted in an employment context in Australia, which is sexual harassment and bullying. Now, sexual harassment is, as it is in many parts of the world, a very challenging and developing and evolving area. Australia, like many other countries, has had a significant shift in terms of employment expectation and employer obligation expectation as a result of the Me Too movement of a few years ago. In fact, the federal government here in Australia has only in the last week introduced a bill into Parliament that is going to introduce some very significant changes to the way in which employers are meant to proactively deal with sexual harassment and the prevention of sexual harassment in their organisations. It is something where employment lawyers like myself, my colleagues, are seeing a huge amount of activity, and that is going to continue in upcoming years. What we see is that the nature of sexual harassment cases are becoming quite blurred and are involving a lot of challenges being mounted in areas such as out-of-hours conduct, social media, extreme challenges through the pandemic and working from home, and a whole range of other things as well. So, as would be the case in numerous other countries, sexual harassment is a key watch-out area. Bullying, workplace bullying, is also a matter that is intensely regulated in an Australian context. In fact, in Australia, unlike very few countries in the world, there is a regime in the Fair Work Act whereby the Fair Work Commission has the power to make what is called a stop bullying order. If an employee in an Australian workplace feels that they are being bullied, and that's defined as another person or group of people engaging in unreasonable conduct on a repeated basis that causes a risk to a person's health, safety, and well-being at work, then the Fair Work Commission can intervene, and the Fair Work Commission can make whatever orders it considers necessary to stop that bullying from occurring. And if they do so, the employer is expected to comply with that. So what we see is that bullying applications and bullying complaints made in organisations are increasingly common. In fact, I would go so far as to say that the incidence of workplace bullying complaints made in Australian workplaces is at extraordinarily high levels and has been the case for several years. In many instances, upon investigation, it's found that those bullying complaints were not substantiated, but what is uncovered is that there were still inappropriate behaviours engaged in. And we know this because our firm does a lot of these workplace investigations on behalf of our clients. So we've covered numerous aspects of the Fair Work Act. We've talked about termination of employment and discrimination and bullying. And the final thing that I want to talk about is the importance of contracts. Now, as I said before when we were talking about the tiers of the pyramid, the National Employment Standards, Modern Awards, Enterprise Agreements, and I mentioned earlier that the final tier was the particular terms and conditions that might apply to an employee because of what is contained in their contract of employment. And it's very common that employers International employers will often ask us to look at their global or international or head office template and make that bespoke and relevant for an Australian context. And I understand why international employers don't like to make too many changes, but as you can appreciate from what I've said, there are some changes that are going to have to be made. Those changes relating to ensuring that you comply with the Fair Work Act in respect of the National Employment Standards, awards and the minimum terms and conditions from an award, all of these things, you don't have a choice. Your contracts have to comply with that. But once you've ticked off all of those boxes, then ultimately you are at liberty to have a wide range of terms and conditions of employment that most commonly relate to things such as bonus schemes, long-term incentives, short-term incentives, other benefits, but also other restrictions and requirements that might be binding or that you as an employer want to impose on employees. And one area where we do a lot of work, as do most employment lawyers in the Australian context, is in relation to what we refer to as restrictive covenants or restraints of trade. In other words, the restrictions that might be placed on an employee's activity after they finish working for you. Now, the law in relation to post-employment restrictions is very complicated in Australia. And it is something that is not dealt with universally in the same way around the country. It is something that is dealt with differently state by state. In the state of New South Wales, of which Sydney is the capital, there is a piece of legislation called the Restraints of Trade Act. And that piece of legislation allows the Supreme Court of New South Wales to read down the terms of a restrictive covenant so that it is reasonable and only reasonable enough to protect the legitimate interests of the employer. So you might have a contract that wants to enforce a non-compete of 2 years against a departing employee, and you might want to make that a worldwide non-compete. The Supreme Court in New South Wales can look at that and say, that's excessive. That's not necessary to protect your business interests. I understand you've got a business interest to protect, but I'm only going to allow you to enforce that for a period of 3 months. And I'm only going to allow you to enforce that in the Sydney metropolitan area, which, as you can imagine, is a far cry from what is written in your contract. So while this is not something that you can give quick and efficient advice in relation to ever, my practical guidance is that if you do want to have non-competes and other restrictions post-employment, make sure that you have drafted those contracts and those clauses of those contracts as solidly as you can, and make sure you've got advice around the enforceability. So in closing, what I'd like to do is just highlight what I consider to be the most critical aspects of action, if you like, for employers who employ people here in Australia. The first critical action is the need to ensure that whatever contracts, policies, procedures you have in place are compliant with your obligations at law, but also that you are in a good discipline of updating employment contracts at least once every 2 to 3 years. As we know, people move roles, people get promoted, people change reporting lines. The courts in Australia expect that employers are going to bear the responsibility to ensure that an employment contract is current and relevant at all times throughout the course of an employee's employment. The next area that I would urge you to consider taking action in relation to is making sure that you've got the appropriate policies in place that deal with matters such as workplace behaviour, including discrimination, harassment, bullying, and the like, handling of grievances, social media, privacy, confidentiality, and a whole range of other things. We as a firm are able to provide these policies as a suite to clients to avoid them having to do all of that work. Or we can look at policies that you have and tailor them for appropriateness in an Australian context. And the third and final area, which is critical for employers, particularly as we are continuing to see shifts in the space of sexual harassment and bullying, is the need to educate, and in particular, the need to educate managers. We do a lot of work in the space of education of managers around performance management, because one of the areas of unfair dismissal which employers really struggle with is where they're terminating employment for reasons of poor performance. And they are very often criticised by courts and tribunals and the Fair Work Commission for not having managed performance in a manner that was expected. And that's why education of managers when it comes to the management of their people and educating managers as to what they need to know about employment law, similar to what I've covered with you today, is really important. And just as important is the need to educate all of your employees, and indeed other people at work, contractors and the like, on their obligations in relation to matters such as sexual harassment, discrimination and bullying. In other words, you as an employer have got a positive obligation to ensure that your employees are not exposed to those inappropriate behaviours, and you're expected to discharge that obligation by educating the rest of your workforce on what they should and shouldn't be doing in a workplace context. Well, I think that brings me to my time and the opportunity to open the webinar up to questions. So, Dan, I'm going to hand back to you to facilitate that particular process.
Brilliant. Thank you very much, Joydeep. And I want to thank you for that incredibly insightful session. I'm sure our audience appreciates how much information you were able to cover in such a short space of time. As you mentioned, we have had a few questions in from the audience, but if you do have a question that you haven't sent in yet, please do. We have a bit of time now that we'll be able to answer those questions. But I'll start with this from Matt. If an employee has a long notice period in their contract, resigns and wishes to end employment earlier than 3 months, mutually agreed by business and employee, is the business required to pay the full contracted notice period and any leave accrued in that time, or just to the date mutually agreed?
Yeah, it's a very good question, and one that applies in practice quite a lot. So the answer to the question is, if it is genuinely by mutual agreement, then what should be happening is that mutual agreement should be triggering a clause in the contract that says that the parties can vary a term in that contract by mutual agreement. And it will typically say that it can be done by mutual agreement in writing. So what's happening in that situation is that you are varying the notice period from, I presume, 3 months to a lesser period. And that means that the employment is being brought to an end as at that date on which it has been mutually agreed. Your leave obligations, accrual of leave, are only to the point at which the employment ends. So you do not have to pay notice beyond that date. You do not have to accrue or pay for any leave beyond that date. But you need to make sure, critically, that there is documentation that ties back in to that clause of the contract. And ideally, you would want to have some kind of separation or compromise agreement that precludes the employee from turning around in a few months' time and saying, hang on, what happened to the rest of my notice period?
Excellent. Matt, I hope that answers your questions. I'm sure it did. A very detailed answer from Joydeep, but if you do want to get in touch, please let us know. Just to let everybody know, we will be sending a follow-up after this webinar with Joydeep's contact information and People and Culture's contact information. So please do get in touch with Joydeep. Our second question here, the bullying jurisdiction in Australia. It's something very unique by global standards. How does it play out in practice, please?
Yeah, it's a good question. It certainly is, as I was saying before, it is quite unique in an Australian in the Australian context. What we tend to find is that bullying is something, and the bullying jurisdiction is something that is more used as a threat. And because employers know that if they do have a claim made against them in the Fair Work Commission, any orders, there's no restriction on the orders that can be made. Employers are really petrified by that, as you would be, because no one really wants to have their organisation managed and controlled by an arbitrary body that can introduce orders such as saying, well, you have to say good morning to someone, or you're not allowed to say good morning to someone unless you have a smile on your face. I mean, we're talking about that level of orders that can technically or theoretically be made. So it's more the fear of that sees employees leverage bullying claims in a workplace context prior to the actual making of a complaint. There have actually been very few decided cases by the Fair Work Commission in the bullying regime in the 10 odd years that it's been in place, but it looms large for employers as something for them to be very worried about.
Excellent. Thank you very much for that, Joydeep. We have some participants from countries where unions and work councils are quite influential. Is that the case in Australia?
Yeah, so unions definitely have a strong role to play, and often what's happened in Australia's history is that where there's been a Labor government in place, as is the case now, unions are a lot more confident. They feel they've got the support of the government. They can tend to exert their influence and power a lot more in organisations. We don't have works councils here in Australia, and some industries, if I talk about the maritime industry as an example, the construction industry, these industries have a very, very strong union presence. So it does depend on the industry. It also depends uniquely on where an organisation is situated. Some states have a much stronger union presence in particular industries than would be the case of that industry in another state as well. So certainly for employers who are looking to set up business in Australia, it's worthwhile doing some due diligence around union presence and union relevance in the history of that particular site or location where they're looking to set up.
I think that's an incredibly important point, Joydeep, so thank you very much for raising that. Our next question, so quite simply, how easy is it to fire someone in Australia?
Yes, well, I think as might have been probably clear from when I was talking about termination of employment, it is difficult in that you need to be aware of the right way in which to go about doing it. Now, what we find is that often the best advice that we can provide to clients in relation to bringing someone's employment to an end is actually less about the law and more about the psychology. It's less about whether you have a right to or don't have a right to, and more about how you're making someone feel about what it is that you're doing. This might sound very touchy-feely for coming from a lawyer, but the reality in this space, and I'm very proud of the fact that I think our firm is really at the cutting edge of understanding and respecting the importance of human relations and psychology and how things look and how things are interpreted and how things are said as critical levers for organisations in avoiding legal risk. It's not just enough to accept the legal advice that says, you can or can't do something and just follow that unless you're going to be paying attention to what a person is thinking and feeling. And you're only going to be able to pay attention to how a person is thinking or feeling if you know what you need to know about them and their background and their history and their relationship with managers. So I'd go so far as to say that the reason why employment termination is difficult is not necessarily because the law is difficult, but because the way in which it is executed does not pay enough attention to the non-legal aspects as much as it should, and it needs to. And the flip side is where our clients who've worked with us for a while, they understand the critical importance of it, and we've got an exceptional track record of having advised on termination. And we advise on multiple terminations every day, and very few of those ever see the insides of a courtroom because of the way in which we're advising our clients to go about it.
Brilliant. Thank you very much for that. Again, Joydeep. I think we have time for one more question, and then we will move into the final part of the webinar. So you just touched on it earlier with the new Labour government, but with this new government now in place, what are the changes we can expect?
Yeah, it's actually a very topical issue at the moment. In the last few weeks, the new government convened essentially a symposium of sorts. There's some discussion in relation to some changes that might be made to the bargaining framework, whereby there is going to potentially be some recognition of multi-employer bargaining. So all of this is again, consistent with what I was saying before, a lot of support and comfort for the union movement and unions here in Australia. I don't think there's going to be too much that we will see change in the context of minimum terms and conditions of employment. And I don't think there's going to be too much that's going to change in the context of the law that applies to termination of employment. I did touch on the respect at work changes, in other words, those sexual harassment law changes. So that's going to be playing out over the next few months. But it will be in that bargaining and the union space. And there's also work happening here and legislative change in the gig economy regulation, as is happening in other parts of the world as well. So there is going to be a little bit more activity than has been the case in the last 12 years or so, which is the period in which there was a coalition government. But I don't think it's going to be too radical or too drastic.
That's good news to hear, I think, Joydeep. What I will do is hand back to you for the final part of this, Joydeep, just to give us, and I know that you touched on this at the end of your presentation, but if there are any key takeaways that you want our audience to leave today's session with, and if you could just let us know how we can get in touch with yourself and People and Culture before we finish.
Yeah, absolutely. Thank you, Dan, and thanks once again to you and the Mondac team for the opportunity. So in closing, I do think it is really critical that employers, particularly those employers whose head office might be outside of Australia, to respect that, yes, while Australia is hundreds of thousands of miles away from other parts of the world, there are some things about doing business and employing people here in Australia that are very similar, if not identical, to what might be the case in the UK or Canada or continental Europe or the US, wherever it might be. But there are some unique features, and a lot of those features are historical. It is important to understand that termination of employment, as I was really emphasizing, is the biggest watch out, and also the fact that it is a very rights-aware society. Don't assume that just because people might come across in an Australian context as very casual and relaxed and joking, and they like to have a drink, all of which is actually quite true and accurate. But when it comes to the seriousness with which they might pursue litigation against you, do not make the mistake of thinking that they're going to take a backward step or that they're not going to be rights aware. Things are quite hot in the context of the employment relationship here in Australia as they are in other parts of the world, and that's something that I would encourage all employers to respect. So we'd be delighted to provide our services and advice and assistance to any of the Mondac family, customers and clients and subscribers and everyone in between. And the best way to do that is to contact me via email, joydeep.hor@peopleculture.com.au. Alternatively, connect with me on LinkedIn. We do tend to provide a lot of our firm's resources and updates via our LinkedIn channels. Our website is also full of lots of resources over the 13 years that we've been in existence as a firm. So for anyone just looking for easily accessible information in relation to the Australian employment landscape, jump on our website, peopleculture.com.au.
Excellent. Thank you very much for that, Joydeep. And once again, thank you so much for your time today and such an insightful, really fascinating session today. Thank you again to our audience for being with us today. I hope you all have a lovely rest of your day. Goodbye.